Sugar Company, where an ordinance was passed by Ormoc City, applicable only to Ormoc Sugar Company. The Supreme Court said this is violative of the Equal Protection Clause, considering that it singled out Ormoc Sugar Company, such that if in the future there will be other similar establishments, they will not be covered by the ordinance because the ordinance referred only to Ormoc Sugar Company. And the only reason why the ordinance made reference to Ormoc Sugar Company is the fact that at the time when it was enacted, it was only Ormoc Sugar Company that was then in existence in Ormoc City. But nevertheless, in order not to violate the guarantee of equal protection, it must be made to apply, or at least the ordinance should have been worded in such a way that it would be applicable to any of the same kind and not simply to Ormoc Sugar Company. In the case of J.M. Tuazon versus non-tenure administration, a property belonging to J.M. Tuazon was also singled out for expropriation. So J.M. Tuazon complained that that would be a violation of the guarantee against, or the guarantee of equal protection, because it singled out its property. The Supreme Court said the mere fact that the property or your property was singled out does not necessarily mean that there was a violation of the guarantee of equal protection clause. You have to remember that in the nature of things, when it comes to expropriation, you cannot possibly expropriate all or nothing at all. So you have to follow a system of priorities. You cannot simply expropriate every land that needs to be expropriated, because the government would not have the necessary resources. So it has to follow a set of priorities, starting somewhere. If the choice was with the property of J.M. Tuazon, the same did not necessarily be considered as a violation of the Equal Protection Clause, provided that there is no showing of ill motive or other improper motives on the part of the legislature in choosing the property of J.M. Tuazon. Now let's talk about some bases used for classification, like sex, not the frequency, gender. Generally, nowadays, sex would hardly be a basis for classification, because what things men can do, women can similarly do, or even do it better. But once upon a time, you have this case of Bradwell, where the Supreme Court of Illinois refused to allow a woman, especially as she was married, to practice law. So you might be wondering, how would they ever have done that? When the matter was elevated to the U.S. Supreme Court, the U.S. Supreme Court upheld the Illinois Supreme Court. So you may be wondering, how would they have done that? Well, it's a matter of perspective. Because nowadays, we look at it from what we know, from where we are. But this case was decided way back in 1873. So at that time, women were not yet considered in the same way as they are now considered today. They were subordinate to the men. They were not equal to the men, especially if they were married. They could not simply enter into contracts like men can do. Even under the civil code provisions, isn't it? There were all those provisions in the past in which the women somehow occupied secondary roles. But under the family code, that has somehow been modified already. So, if you look at it from the perspective of the times, you can understand how it was. Anyway, if anything, this can only prove how far the women have come when it comes to equality. So, nowadays, whether you are a man or a woman, you can practice law. I'm just afraid that in the future, it might be the turn of the women to get even and prohibit men from practicing law simply because they are men, and worse if they are married. They might also be told to stay home, clean, wash, and cook, right? Where's your prospective husband? Okay. In the case of City of Manila versus Lagyo, one of the standards used by the ordinance was use of women as tools of entertainment. The Supreme Court said that's unfair. It's not only women who could be used as tools of entertainment. Men could similarly be used for that purpose. So if you have, for instance, women who are scantily clad dancing in cages, you also have macho dancers, isn't it? And if you have women prostitutes, you also have men servicing their fellow men or matrons, correct? So they could similarly be used as tools of entertainment. On legitimacy, this is considered as one of the valid basis for classification. As a matter of fact, you very well know that if you are legitimate, then you are entitled to twice the share of the legitimate of any illegitimate siblings that you have. So it is not the fault of your illegitimate siblings that they might have come to this world as such, but still, it's considered as part of the public policy to promote and encourage legitimacy as against illegitimacy. And one way of doing that would be to provide for this kind of classification in regard to legitimacy or illegitimacy. On qualifying examinations, you have that old case of Toblerone. No, that's a chocolate brand. It's Toblerone. In that case, the NMAT examinations normally change the passing grades every time that there were these exams. So the problem here is about alleged violation of the Equal Protection Clause, considering that every year they might change the passing grade. So for instance, one time somebody took the NMAT and got a grade of 74, but the passing grade was 75. Therefore, he was not admitted. The following year, he did not take the NMAT, but the passing grade was reduced to 70. So can he not complain of unfairness? Why should they not all be treated in the same way, such that the passing grade should always be 75? Because now, he did not take the NMAT, and the passing grade was 70. But if that would have been the passing grade at the time he took the NMAT, then he would have been admitted to the medical education. The Supreme Court said each batch could be considered as a class by itself. You cannot simply consider everyone at the same level or same classification, because there are some factors to be considered. For instance, it might be that in a particular year, there were so many who took the NMAT, but there are only a limited number of slots available to be filled up. So you have to come up with the higher passing grade. The following year, there might be a few who took the NMAT, and therefore you would again have to adjust in order to accommodate more and fill up the slots available. Or, in another year, the questions might have been so difficult that if you retain the old passing grade, then very few would ever get admitted. Accordingly, you would again have to adjust, lower the passing grade. For the past 3 years, the Supreme Court had also been altering the passing grade for the bars. One time it was 70, other time, was it 72? And this year it was 71. So for your batch, it's payback time. It should be about 85. Another case involving the NMAT, and which also has ramifications for the Equal Protection Clause, is that case of Dex versus San Diego. Here, the NMAT has this 3-plank rule, such that if somebody interested in medical education takes the NMAT 3 times and his performance is consistent, then that would be the end of his medical dreams. So, the problem posed is this not a violation of the Equal Protection Clause, considering that for other professions, there is no such 3-plank rule? The Supreme Court said, this is not to underestimate or denigrate the other courses, but it cannot be denied that when it comes to the medical education, we need the best and the brightest. Therefore, this requirement. And moreover, it's done. It's done. Moreover, the Supreme Court said, for someone who has taken the NMAT 3 times and has not made it, then obviously there must be something wrong, that he is not really meant for the medical profession. He might be very good in some other areas, but then he is not for medicine. So, if you cannot make it to medicine, why don't you just take up law? No, the Supreme Court did not say that. Anyway, what the court was saying is, it's not only medicine that matters in life. You can try your hand elsewhere. You might be better off in some other courses instead of insisting on a course that keeps on vomiting you. So that's the case of Dex versus San Diego. On crimes and punishments, we have that old case of Ching Kwan. Here, Ching Kwan was complaining about the adjustments made in the fine depending on the means of the conviction. So he said that's a violation of the Equal Protection Clause. We committed the same crime. Why should we be given different fines simply because we don't have the same means? For instance, one who hardly has anything in life may be fined 10 pesos. But for someone who is earning, let's say, 1,000 pesos a day, he may be fined 100 pesos. They committed the same kind of crime. So is that not unfair? The Supreme Court said, no, actually, it's more in accordance with the Equal Protection Clause. Why is that? You have to remember that one of the objectives of punishment is to somehow deter the commission of the same crime by making the convict realize that what he did is wrong. So one way of doing that is to come up with that kind of a penalty that would instill in his mind that idea. So if you are with hardly anything, a fine of 10 pesos would really mean much. However, for someone earning 1,000 pesos a day, you fine him 10 pesos and perhaps you would not even feel it. So you would have no qualms, no second thoughts about committing the same crime again. Therefore, to make him realize it in the same way that it is somehow nailed into the consciousness of the person who hardly has nothing. You have to increase the fine, make it like 100. So in that way, it's not that small anymore. It's not something that the person could easily ignore. In Gumabon versus Director of Prisons, what we have here is conviction of Gumabon and Company for rebellion at the time when the Supreme Court couldn't yet make up its mind as to whether there's such a thing as rebellion complexed with common crimes. So they were convicted of rebellion complexed with common crimes. That would mean that the penalty would be imposed in its maximum period. Subsequently, however, the Supreme Court held that there is no such thing as rebellion complex with common crimes. Therefore, those who were convicted after Gumabon were now given a penalty which would be appropriate to that simple rebellion only. When Gumabon and the others had served the prison term equivalent to what was imposed on those who were subsequently convicted, in which the Supreme Court already applied the rule that there's no such thing as rebellion complex with common crimes, they petitioned the Supreme Court to be released, claiming, among others, violation of Equal Protection Clause. And the Supreme Court agreed with them. The Supreme Court said that they could not stay longer than the period of imprisonment imposed on the other convicts who were also found of rebellion, but who benefited from the new doctrine that there could be no rebellion complex with common crimes. In regard to Halus Hons, you still remember him? So, he was convicted of statutory rape, among others. He appealed to the Supreme Court, and while he was awaiting the outcome of his appeal, his constituents re-elected him to Congress. Therefore, he asked the Supreme Court that he be allowed to attend the sessions of Congress. The Supreme Court said, "We cannot validate badges of inequality, no matter that you may be a congressman, considering that you were convicted of a crime for which you have to remain in jail while awaiting the outcome of your appeal, just like any others convicted of the same crime. Then we cannot do otherwise but to keep you in jail. We cannot grant you an opportunity to get out of your cell every now and then simply to attend your congressional hearings. You have to be treated just like the others." And in this regard, you also have the case of Trillanes. Trillanes, as you very well know, led that picnic in Oakwood one July day in 2003. They planted explosives instead of plants and flowers. But before the day was over, they were returned to barracks, and subsequently they were charged for what they did. Subsequently, in 2004, Trillanes ran for the Senate and won. Now, he wants to attend also the sessions of the Senate. He applied for that permission with the trial court presided over by Judge Pimentel. Which restaurant is that for? Perhaps some of those attending the bar review would simply be attending for the sake of taking a look at you. Would you ever believe that she is a law student? Thank you. Judge Pimentel denied the plea of Trillanes. So the case went up to the Supreme Court, and Trillanes tried to differentiate his case from that of Halos Hos. He said, in the case of Halos Hos, he was charged with a political or a common crime. In his case, Trillanes, he was charged with a political crime. In the case of Halos Hos, he had already been convicted by the trial court, and he was just awaiting the outcome of the appeal. In this case, there is still ongoing trial in the RTC. In the case of Halos Hos, he also claimed that for some time he was a fugitive from justice. Insofar as Trillanes was concerned, he submitted himself to the jurisdiction of the authorities. Supreme Court said, no matter the distinctions that you want to point out, what is important is you are charged with a crime in which you have to await the outcome in jail. So it does not matter whether it's still at the trial stage or already on the appellate stage, or whether the crime that was charged against you is political or common crime. And about your contention that Halos Hos was a fugitive and you were not, the Supreme Court said, what did you do one November morning? Did you not leave the RTC and go to Manila Pen? So that is a form also of fleeing from the arms of the law. The Supreme Court said, stay in jail. And in the case of Nicolas, so remember Nicole and Smith? Smith was convicted by the trial court of rape committed against Nicole. Smith, being an American serviceman, was spirited one midnight from the Makati City Jail to the U.S. Embassy. And there he stayed until the Supreme Court had to decide this case. So the act of transferring Smith from Philippine jail to the U.S. Embassy was questioned. And there was a contention that this would be a violation of the Equal Protection Clause, considering that others who are convicted of the same crime have to stay in Philippine jail. And yet, for Smith, he had to stay in the U.S. Embassy. The Supreme Court said you have to correlate this with international law. Under international law, ordinarily, a host state where foreign troops might be found momentarily, ordinarily would have no jurisdiction over these foreign troops, except to the extent that it is covered by an agreement between the host state and the home state. So if there is no agreement, the general rule is that the host state would have no jurisdiction over these troops because they are extensions of the foreign state. So here, when it comes to the custody of American servicemen who might be charged with crimes committed in the Philippines, that would be subject to arrangements between the Philippine government and the U.S. government. Now let's talk about tax evasion. So you have the case of Santos versus People. That's Judean. People in show business perhaps they also desire as much as possible to minimize having to pay taxes. So in the case of Judian Santos, she reported an income of 8 million pesos. The BIR did some investigation and found out that she earned instead 16 million. Therefore, she was charged before the courts. Another personality who was also charged was Regine Velasquez. But subsequently, the case of Regine was dismissed. And this was used as a ground by Judian Santos, among others, to claim that there was a violation of the Equal Protection Clause since her case was not similarly dismissed. The Supreme Court said that's not a valid argument for equal protection. The mere fact that a criminal case of the same nature against someone else is dismissed does not necessarily mean that your case would also be dismissed. For one, there could be differences in the facts. And even assuming that there was a mistake in dismissing the other case, still that would not justify the dismissal of another criminal case. Otherwise, if someone is let go, does it necessarily follow that all others who have committed a crime should similarly be set free also? Obviously, that's not the case. So the Supreme Court said the case against you would have to continue. On how many more days before the election? 2 weeks, right? Less than 2 weeks. And you're supposed to have the first nationwide automated elections. So that brings us to the earlier case of Loong versus Comelec. This is a case in which Mr. Murphy made known that his presence would not be ignored. You still remember Murphy's Law? If anything can go wrong, it will. And that precisely is what happened here. In 1998, there was an experimental use of automated elections or automated voting or counting machines in the ARM area. The moment they started using the machines, however, Mr. Murphy already showed up. So he bundled everything up. The machines could not accurately read the ballots. What the Comelec did was to revert to the traditional way of cheating. Manual count. When the results were out, Loong, a gubernatorial candidate, lost. Now he's before the Supreme Court claiming that there should be a special election for the position of governor. The Supreme Court said, we cannot grant your request. Loong claimed that the Comelec had no authority to revert to manual count. That's again in the news, isn't it? Parallel manual count. And the Comelec said, no way. So let's just hope we will not have Loong repeated on a grand scale. The Supreme Court said, if the counting machines did not work, notwithstanding that there was no provision in the law for manual count, then you cannot deny to the Comelec a means to determine the will of the electorate. The Comelec is supposed to count the votes. So if the machines didn't work, then you cannot blame the Comelec for going back to manual count, because that would be the only way by which it could now determine the will of the voters. And in regard to equal protection grounds, the Supreme Court said, if as claimed by Loong, that everything for the gubernatorial race should be disregarded because of the failure of the counting machines. You have to remember that it was not only for the position of governor that there was an effect. It affected the positions for board members as well as for the vice governor. So if you were to follow the logic of Loong, then all of these positions should have a special election. To hold a special election only for the position of governor would be a violation of the guarantee of the Equal Protection Clause. In regard to, what again is the cutoff? Not December 2010? So you are not supposed to discuss any of the newer cases or what? Okay, just in case, reserve, right? Let's talk about Fariñas. Before, the provision of the law was that if an appointed official filed his certificate of candidacy, then he would be deemed resigned from his position. At the same time, if an elective official filed his certificate of candidacy for a position other than what he was occupying, he would also be deemed resigned from his position. So if he was vice governor and he filed the certificate of candidacy for governor, then he would be deemed resigned from that position of vice governor. But by amendment of the law, this effect on elective officials was lifted. Therefore, the automatic resignation effect was only with regard to appointed officials already. So in the case of Fariñas, there was a claim that this would be a violation of the Equal Protection Clause. If you lifted the effect insofar as elective officials are concerned, why should you not do it also with appointed officials? The Supreme Court said there is a valid distinction between appointed and elective officials. For one, elective officials have only a short term of office. Appointed officials are generally with security of tenure, and they may stay in their positions until retirement. And then also, when it comes to appointed officials, as part of the civil service, they are prohibited from engaging in partisan political activity. For elective officials, they may also be part of the civil service, but their positions are precisely partisan. So when they file their certificates of candidacy, they engage in partisan activity, but that's already where they are. Insofar as the appointed officials are concerned, the moment they file their certificates of candidacy, they now undertake partisan political activity, which would be incompatible with the idea that they are still part of the appointed branch or agencies of the government. So, in that case, the Supreme Court said there is no violation of the Equal Protection Clause. Then last year, the Supreme Court surprised everyone when it came up with the case of Quinto. Justice Nachora, writing for the majority, said that the provisions of the law and resolution which considered appointive officials as automatically resigned from the time of filing of certificate of candidacy is unconstitutional. It violates the Equal Protection Clause. It's also guilty of overbreadth. Chief Justice Pono dissented. Within a few weeks, the Supreme Court reversed course. And this time, Chief Justice Pono wrote the majority opinion reversing the earlier one. And Justice Natura was reduced to coming up with a dissenting opinion. It's a wheel of fortune, right? In the original decision, Justice Natura claimed that whatever was decided in the case of Fariñas was merely obiter. Therefore, it was not determinative of the issue in the case of Quinto. He also said that the classification made by the law between appointive and elective officials would violate that requirement of the Equal Protection Clause, that the classification must be germane to the purpose of the law. So if the purpose of the law is to prevent those who file the certificates of candidacy from making use of their positions to gain undue advantage or to pressure their subordinates and some other evils, the Supreme Court majority said that can be done by both elective and appointive officials. So there is really no valid basis. And then with regard to the overbreadth doctrine, Justice Natura also said that the law tries to cover everyone, no matter what appointive position he may be occupying or not. Whether one that is influential, high up in the hierarchy, or one which is just a lowly government employee, like a clerk, or even perhaps a janitor. So why should it have the same effect on everyone when they would not have the same kind of influence upon the other members of the government service? On a motion for reconsideration, and as we have said, Chief Justice Pono wrote the majority resolution. Justice Pono maintained that Fariñas was not obiter. It was decided on the merits, and the issue was argued and was material to the case itself. So it was not obiter. Insofar as the overbreadth doctrine is concerned, he said that you cannot require Congress to simply cover everything at once. So you may start somewhere, begin with this, and in the process you may include some others, but that would not necessarily mean that it's already guilty of overbreadth. So Congress may eventually lower or narrow down the effect of this automatic resignation thing, but in the meantime that Congress has chosen to include everyone in the appointive service, that should not be enough basis to consider it as unconstitutional. Another case of recent memory that would again illustrate the Supreme Court's changing views and dispositions would be the case of League of Cities. So in that particular case, certain municipalities were waiting to be converted into cities, I think during the 11th Congress. During the 11th Congress, towards the end of its existence, an amendment to the local government code was enacted. And it increased the annual income requirement for conversion of municipalities to cities. Under the old provision, 20 million would be enough. Under the new provision, it would have to be 100 million. So this amendment was passed, but the bills for the conversion of the cities, or the conversion of the municipalities to cities, had not been acted upon. So, 11th Congress came to an end. The 12th Congress came into existence. The municipalities whose pending bills were not acted upon were able to get the House of Representatives to come up with a resolution exempting these municipalities from the new 100 million peso annual income requirement. Unfortunately, the Senate did not act on that resolution. The 12th Congress again came to its end. Nothing came out of that resolution. Then during the 13th Congress, another resolution was passed by the House. But again, the Senate was not able to act on it. In time, Senator Pimentel advised these municipalities that they should rather have individual bills. And in those bills should be incorporated a uniform provision exempting them from the new 100 million peso annual income requirement. These bills were duly passed by both houses. They were sent to GMA, and just like a hen, she sat on them such that after 30 days they hatched into laws. So when they became laws, the League of Cities went to the Supreme Court questioning the validity of their enactment. They claimed that they did not comply with the local government code. In the original decision of the Supreme Court way back in 2008, the Supreme Court said yes, these laws are unconstitutional. For the basic reason that at the time when they were approved, the new provision of the local government code requiring a 100 million annual income requirement had already been law for a long time. So, pursuant to the Constitution, they are supposed to comply with what is provided for in the local government code. The requirements could not be found elsewhere, like in the individual bills themselves. They have to comply with what is in the codified requirements. That is how the Supreme Court read the requirement of the Constitution for the setting up of a local government code, which would govern, among others, the creation or conversion of municipalities into cities. And on equal protection ground, the Supreme Court also said that when it comes to the requirement, the third requirement, that the classification must not be limited to existing conditions only, the cityhood bills or laws fail to comply with the same, because they are the only ones which would be given this particular situation. It would never happen again. So it's limited to them only. it's limited to existing conditions, their conditions. A motion for reconsideration was filed and it was denied by, I think, a vote of 7-5. A further motion was filed and still denied. The case became final and entry of judgment was made. Then there was an interesting development, I think, following a third motion, where it was now pointed out that if the Supreme Court were to decide a law as unconstitutional, it must be by a definite majority and not through the uncertainty of a split decision. Because in the last motion for reconsideration, there was already a split, 6-6. So this was capitalized upon by the new majority, and the new majority came up with a reversal of that final decision. So how did the majority now reason out? The majority said that the individual bills for each municipality should be considered as embodying an exemption from the requirement of the local government code for that 100 million annual income. It did not necessarily be that this exception should be embodied in the local government code itself. So it can be found in individual statutes passed by Congress itself. Because in any event, it is the Congress that provides for the local government code. So it can also provide exceptions to what are included in the local government code, not necessarily by amending the local government code itself, but coming up with individual laws in which these exceptions could be found. And what about that argument regarding equal protection? That it is not limited to existing conditions only. The Supreme Court said these municipalities constituted a class by themselves. So they did not have the same condition applicable to other municipalities in the future. I don't know if that has already become final, because after the League of Cities lost, that was the time that they also filed a motion for reconsideration. So how many motions they might file, we never know. Anyway, when you come to think of it, this case is also something that you can relate to what happens in interpersonal relations. Behind this constitutional issue is a fight for money. Why is that? Think of yourself as children who are now looking at their inheritance. So assume that you are only two in the family, and your parents leave you a fortune of 100 million. So each of you would be entitled to 50 million. What if a month after the death of your parents, you suddenly realize that there are now 50 other claimants who now say that they are also the children of your father? So that would considerably lessen your inheritance, is it not? And you would now fight until you use up all your resources. At the end of the day, you'll have nothing left, right? In this case, the League of Cities also wanted to preserve their share in the IRA. So for the cities, they have a certain allocation, which they share among themselves. But if you increase the number of cities, then obviously their share would, to that extent, also diminish. So that basically, I think, is the background why the League of Cities was so insistent on denying the conversion of the municipalities. The practical side of it. In regard to the under-inclusiveness argument, this is basically like saying, why is it limited to us only? Why did not the law include others who could similarly have been included? But the Supreme Court has said that this is generally not a valid argument against the classification that might be made by Congress. An example for this is the case of the Guzman versus Comelec. Here, there was a law that was passed which provided for the transfer of municipal and city election officers every 4 years from the congressional district that they are presently located to some other congressional districts. So the contention here is that it violates the Equal Protection Clause, in the sense that it is only the election officers which are affected. They are the only ones moved elsewhere. What about the other Comelec employees? They could have been in the same position for 4 years or even longer. Why are they not being transferred likewise? So this is like the under-inclusiveness argument. The Supreme Court said that's not a valid basis for attacking this classification. Congress is given discretion to draw the line, to determine who may be included within a particular classification. And the mere fact that it did not include more cannot be considered as enough ground to attack it on equal protection issue. Insofar as the election officers are concerned, these are the persons who are in a position to possibly affect the outcome of the election, such that if they become too close or familiar with the local political leaders, then this may affect their ability to perform their jobs, to come up with clean and honest elections, because they would now have become influenced by these persons that they have become familiar with. So it is necessary that every 4 years they have to be moved somewhere else. Insofar as the other Comelec employees are concerned, they are not similarly situated. They are in no position to affect the outcome of the election, just like the election officers. Therefore, if Congress chooses the election officers only for transfer every 4 years, that could be, or there could be no valid constitutional basis for invalidating the same. Again, in the case of Serrano versus Gallant Maritime, the Supreme Court struck down the classification between those OFWs who have remaining contract periods of less than 1 year and those having more. And for the purpose of striking it down, it even made use of strict scrutiny. And the court found that there was no compelling interest that could have justified coming up with that kind of a classification. In regard to inverse equal protection, the guarantee of equal protection means that equals are to be treated equally. So that if you treat them unequally, then that would be a violation. Inversely, If you treat unequals equally, that would similarly be violative of the Equal Protection Clause. For instance, let's imagine how you were during your regular law course. This is fictional and imaginary for entertainment purposes only. So let's assume that during your school days, you were very conscientious in your studies. You never go to class unprepared. Your classmates hardly go to class prepared. When you're called to recite, you embarrass your professors. Why? Because they run out of questions for you.
Okay.
When your professors ask your classmates, they also get embarrassed. Why? Because they should have known better than to even ask. Before your written exams, you also study a lot at Starbucks. Your classmates, they study at the beer house. When your professors start checking your booklets, he would have a hard time finding a wrong answer in your booklets. When he checks the booklets of your classmates, he hardly would find a correct answer. The final grades come and all of you get 75. Equal treatment, right? Is that fair? Obviously, it's not. So that is inverse equal protection. It's not fair. It's likewise violative of the Equal Protection Clause. In the case of Philippine Judges Association versus Prado, the Supreme Court made use of this principle to reinstate for itself, or the judiciary, the so-called franking privilege. The franking privilege is the use of the mails without having to affix a postage stamp on the envelope. So during election time, you may suddenly have noticed that there are now envelopes addressed to you or your parents coming from members of Congress. All of a sudden, they remember you. And if you would notice, at that corner where the stamp is supposed to be placed, there's none. Instead, there's just a notice, and that is for the franking privilege. Under the old setup, when it was still the Bureau of Post, Congress, the President, the Judiciary, aside from many other offices, were given franking privilege. When the Bureau of Post was to be replaced by the Philippine Postal Corporation, Congress tried to limit the grant of franking privilege. It retained the franking privilege for itself, Congress, as well as for the President and some other offices. However, it removed it from the judiciary. So the judges complained. And how did the Supreme Court make use of this principle of inverse equal protection? The Supreme Court explained that the judiciary is one of the three great and co-equal branches of the government. It is of the same level as Congress and the presidency. Therefore, it should be treated in the same way. But what happened under the law that created the Philippine Postal Corporation is that the law relegated Congress to a status similar to other minor offices or other persons who used to be entitled to the franking privilege. So the judiciary was now treated like a minor player from whom the franking privilege was removed. So the Supreme Court said, obviously, the judiciary does not belong in that category. It belongs to the same level as that of the President and Congress. So to treat it the same way like those minor offices would be to violate the Equal Protection Clause. Accordingly, to rectify this mistake, it must be reinstated to the same level as that of the President and Congress. And in that, the court was able to take back the franking privilege. Now let's talk about the doctrine of relative constitutionality. This one you can relate to that familiar line that beauty is in the eyes of the beholden. If nobody else can appreciate your beauty, then you have to take care of doing it yourself. So you can go in front of a mirror and ask the mirror, "Mirror, mirror on the wall, I'm beautiful, am I not?" So under the doctrine of relative constitutionality, a law may be constitutional from one perspective, but then would be considered as unconstitutional from another perspective. How would that be? You would either be a man or a woman, not in between, right? For that, we have the case of Central Bank Employees Association versus Bank Sentral ng Pilipinas. When the Congress had to come up with Bangko Sentral ng Pilipinas to take over the powers and the functions of the Central Bank of the Philippines, it created a two-tier classification for its employees. Those with salary grades 19 and below were covered by the salary standardization law. Those occupying salary grades 20 and above, or the managerial employees, were exempted from the salary standardization law. So, the rank and file employees obviously complained. Why are the managerial employees exempted while we are made subject to the provisions of the salary standardization law? The Supreme Court said the classification in the law is valid. You have to remember that those who are supposed to occupy salary grades 20 and above are supposed to be persons who would possess special skills, knowledge, or expertise. The very kinds of people that Bangko Sentral ng Pilipinas would need if it were to perform its duty as the central monetary authority. You cannot have mediocre people occupying these positions, isn't it? But these same positions, which require these kinds of persons, would remain unfilled or would have constant turnovers if you did not provide competitive compensation packages compared to the private sector. Because these persons that you need would also be in demand in the private sector. So it may happen that you're early for the testimonial. Leave something for me. You can't wait for next year, right? So, for instance, if you followed the salary standardization law, a person made to occupy a particular position may only be entitled to receive a monthly salary of 25,000 pesos. However, if that person were to go to a counterpart position in the private sector, he may be receiving 50,000 pesos. So if that were the case, how do you expect your positions in Bangko Sentral ng Pilipinas to be occupied by the kind of people that you need? Chances are, these persons would rather go to the private sector because it offers a much better compensation package, isn't it? Because of that constraint caused by the salary standardization law. Therefore, the need to exempt this position from, or these positions from the salary standardization law. How about for those rank and file positions, salary grades 19 and below? The problem would not be as critical because these are positions that are occupied by persons who don't necessarily have to have the special skills or training or other similar qualities. So even if they leave Bangko Sentral, for instance, it would be not that difficult to find replacement for them. They might be clerks, secretaries, and the like, and they could be readily available in the market. Accordingly, the need to exempt them from the salary standardization law is not that necessary or imperative. So, in that regard, the Supreme Court said the classification is constitutional. There is a valid distinction between managerial and rank and file employees, and that distinction is substantial enough and it is germane to the purpose of the law. However, the Supreme Court also noted that after Congress enacted the law creating the Bangko Sentral ng Pilipinas, it also revised the charters of several GFIs, or government financial institutions. Bangko Sentral is, of course, a government financial institution. So which institutions are these? Like GSIS, SSS, DBP, PDIC. And what about these GFIs? What did Congress do? In all of these new or revised charters of GFIs, Congress uniformly excluded all employees from the coverage of the salary standardization law. So whether they were rank and file or managerial employees, they were exempted from the salary standardization law. So given this background, the Supreme Court said we can no longer justify this discrimination against the rank and file employees of the Bangko Sentral ng Pilipinas. They are also employees of a GFI, Bangko Sentral ng Pilipinas. And there is no substantial distinction between them and the other rank and file employees of the other GFIs. So now you have relative constitutionality. And constitutional from the point of view of the classification within the law itself, but already deemed unconstitutional in view of the fact that there were subsequent laws affecting similar government institutions which uniformly exempted all government all employees, whether managerial or rank and file, from the salary standardization law. Now let's proceed to the prohibition against unreasonable searches and seizures. you have to understand that this provision is not a prohibition against searches and seizures. It is only a prohibition against unreasonable searches and seizures. This you have to correlate again to the nature of society that we have. It is supposed to be a Republican state. So as a Republican state, the state has to serve the people, not the people being considered as slaves. Being the sovereign, the people have to enjoy freedom. They have to be free from unwarranted or unnecessary governmental intrusions. They have to have privacy. So, they can stay in their houses safe, secure, and assured that nobody would just enter their houses, even the government, unless there is a justification for the same. Or that they can walk the streets, move from place to place without being harassed, stopped, or searched. So that basically is the idea. It would therefore be only when there is cause for the issuance of a warrant for a search or seizure that people may then be subjected to that kind of treatment. But as a general rule, they should be free from government interference in their lives. So take note throughout our discussions on this provision on unreasonable searches and seizures that the idea of reasonableness is ever present. And the Constitution itself already provides the starting point. In order that a search or a seizure is deemed to be reasonable, there must be a warrant to authorize it. So without a warrant, a search or seizure is presumptively unreasonable or unconstitutional, unless it falls under any of the recognized exceptions. Now let's talk about the issuance of the warrant. Take note that even in the issuance of warrants, the idea of reasonableness is already present. How? A warrant cannot just be issued by anyone. It has to be issued by a judge. And the reason for that is, it is assumed that the judge, who is detached from the act of the law enforcement agencies, would be in a better position to take a better look at disinterested view of what may be presented before him, seeking a warrant. Because if you gave the authority to issue warrants to the police authorities themselves, then chances are they would not be able to exercise that kind of caution, that kind of care, which would ensure that there be no unreasonable searches and seizures. Because policemen are, by training and by the nature of their job, supposed to solve crimes as soon as possible. So in that regard, it's very likely for them to engage in shortcuts. Whereas if you let a judge stay in the way for him to first find out if there's a basis or not, then you can assure the people of a reasonable search. You still remember what happened to Ed or Ted Filon? So if you simply allowed policemen to do it on their own, you can just imagine the kind of unreasonable searches and seizures that the people would be subjected to. Why would they care about these niceties of determining probable cause, for instance? they would always say, we know. And they would say, we have to act as soon as possible before everything else is done. But that should not be the way, because otherwise the rights of the people would be trampled upon. So the judge would be the one to determine the existence of a probable cause. And when it comes to the determination of probable cause, it's not enough that it is supported by the affidavits of the applicant and the complainants that he may produce. Because normally, affidavits would be self-serving. So, the requirement that the judge ask searching questions to determine whether there's really basis or not. Again, you can see the idea of reasonableness. Also, it is required that the person appearing before the judge should have personal knowledge. So you cannot just rely on hearsay evidence, because hearsay evidence is generally unreliable. There is also the requirement of particularity of description in the warrant itself. Again, you can appreciate that this has something to do with reasonableness. Because if there is no particularity of description, then you can now have a roving commission, a fishing expedition, where the policemen can do whatever they want, because the warrant is general enough to encompass a lot of things, which may not even be related to the crime that they're trying to solve. So you have to be more particular so as to delimit the authority of the policeman serving the warrant. In regard to modern technology, a problem that has come about and which has stayed until now is about film piracy. So way back in the 1970s, we had the advent of Betamax. With Betamax, people could then watch in the privacy of their homes movies, old or new, legitimate or pirated. So we have the case of 20th Century Fox. In that case, the Supreme Court said that to establish the existence of a probable cause relative to film piracy, the applicant must be able to produce the master tape. The court spoke in a manner that gave the impression that the master tape is indispensable, such that if you cannot produce it, you cannot prove the existence of a probable cause relative to film piracy. Some years later, however, the Supreme Court came up with Columbia Pictures, and the Supreme Court then backpedaled. It now clarified that it did not really mean it that way in the case of 20th Century Fox. While the master tape may be important, it would be very helpful. It did not necessarily mean that without the master tape you cannot prove probable cause. So, provided that the other evidence would be good enough, you can still prove the existence of a probable cause about film piracy even without a master tape. So that was way back in, I think, 1996. Now, it's more than 10 years later, we still have the same problem. And it is greatly abetted by law students. So how many films does a DVD have now? It used to be that for a VCD, you would have 2 or 3 discs just for one movie, right? Now you have one DVD disc and several movies. Another modern technology that also has legal ramifications would be the replacement for the typewriter. Nowadays, if you still want to see a typewriter working, I think you have to go to a police station, right? Or some other courtrooms. I miss the sound. During the times of the typewriters, especially when they were simply manual typewriters, all that you would need would be the machine itself. The ribbon, coupon band, carbon paper, onion skin, and a ton of eraser. Now, you don't need the eraser. You need the machine. But you also know that the machine alone would not work. You need software. Therefore, that brings about, again, another problem with the law. Copyright infringement. So we have the case of NBI Microsoft versus Huang. Huang used to be an authorized reseller of Microsoft products. Then came to an end. Microsoft suspected that Huang was selling fake Microsoft products. So together with the NBI, it applied for a search warrant. The premises of Huang were searched, and NBI was able to confiscate some installer disks or CDs. The DOJ dismissed the case, claiming that there was no probable cause, considering that Huang used to be an authorized reseller of Microsoft products. So how do you now determine whether the products that he was selling were legitimate or not? The Supreme Court said, DOJ, you're wrong. What were confiscated in the premises of Huang were installer CDs. So what about if they were installer CDs? Installer CDs contain more than one program. Why would that then be indicative of a probable cause of copyright infringement of this software? The Supreme Court said because Microsoft does not produce installer CDs. So if Microsoft itself does not produce installer CDs, then obviously those installer CDs that were found in the premises of Huang were pirated. So installer CDs would have more than one program per disk. But for Microsoft, it's only one per disk. So that's the case of NBI Microsoft versus Huang. Insofar as the language of the Constitution regarding the issuance of warrants is concerned, it gives the impression that whether the judge is issuing a warrant of arrest or a search warrant, he must personally examine the complainant and the witnesses he may produce. However, by practice and by doctrine, the Supreme Court has recognized and sanctioned the practice of judges of issuing warrants of arrest without having to see face-to-face the complainant and the witnesses. So, the wording of the Constitution regarding personally examining the complainant and the witnesses would apply to search warrants, but not to warrants of arrest. Why is that? You have to remember that the cases which are filed before the court have already been sifted through by means of a preliminary investigation. So during the preliminary investigation, the public prosecutor would now determine whether there's a probable cause to file an information in court. If the public prosecutor determines that indeed there's a probable cause, then he would file the information together with the records of the case. It would be from this that the judge would now determine the existence of a probable cause. So he may issue the warrant of arrest without ever having to see the complainant and his witnesses. However, you have to take note that the judge must have before him not just the information. Why? Because the information would just signify the conclusion of the public prosecutor that there is a probable cause. But that is not binding or conclusive on the judge. And moreover, the probable cause to be determined by the public prosecutor is different from the probable cause to be determined by the judge. The probable cause determined by the public prosecutor is for the purpose of filing the case. So it is to find out if there's enough basis to think that the person charged may have committed the crime and is probably guilty. On the other hand, the probable cause that is to be determined by the judge is about whether he may have committed the crime, which would then warrant his being arrested. So the probable cause to file information, that is the job of the public prosecutor. It is executive in nature. The probable cause to determine the existence of the basis for the arrest of a person is a judicial function. So they could not be equated with each other. There are times, however, when the judge may be asked to determine probable cause after an information has been filed. So that may be intended to prevent him from automatically issuing a warrant of arrest simply because an information had been filed. Now let's take the case of Talingdan versus Eduarte. Talingdan is a practicing lawyer in Isabela. Why are you smiling? You're not the one from Isabela. Or would that be by affinity? Then one day, he got the surprise of his life. There was a warrant for his arrest. So how would that be when he didn't know that any criminal case had been filed against him? So what he did was to go at once to the RTC that issued that warrant of arrest. The judge who issued the warrant was Judge Eduarte. Talingdan informed Eduarte that there was a problem with the warrant that he issued, because it turns out that the information was filed directly with the court without undergoing any preliminary investigation. Eduarte realized his mistake and therefore quashed the warrant. Just the same, Attorney Talingdan brought up the matter to the Supreme Court, and the Supreme Court required Judge Eduarte to explain. So Judge Eduarte came up with this explanation, designed to expedite business in his courtroom. To do that, he devised a checklist. So that checklist would contain what should be determined to be present before a warrant of arrest could be issued out. The judge gave this to his criminal docket clerk with the instruction that every time there's an information file, this criminal docket clerk would then consult the checklist. So if those things indicated in the checklist are present, she would start typing out the warrant of arrest, after which she would place it on the desk of the judge. So when the judge would see that warrant properly accomplished, he would just affix his signature. Very efficient, right? The Supreme Court said, but that's not the way that you're supposed to be doing your job. You are to personally examine the records, for instance, to determine if there is a probable cause. Instead, what you have done is to practically delegate that to your criminal docket clerk. So she would now be the one to determine the existence of those things indicated in the checklist. And the only thing that you'll be doing is to affix your signature. That is not the role of a judge. So for that, Judge Eduardo was fined. Unfortunately for Attorney Talingdan, before this case was decided by the Supreme Court, he again received another warrant. And this time, it was signed by St. Peter. So when the decision of the court came out, he was no longer to be found anywhere, even if you were to file for a writ of amparo. Anyway, he left something by which law students, bar reviewees, and judges could learn from. In regard to that, there's another case involving a judge who also tried to simplify things in his sala. So what he did is to come up with a ready set of questions whenever there's an application for a search warrant. And this would then be read by the stenographer to be answered by whoever is the one applying, after which the answers would be put down in writing. The Supreme Court again said, of course, that's not the way to do it. It's the personal obligation of the judge to determine the existence of a probable cause. So if you remember in that old case of Batch and Company, the judge asked the clerk of court to be the one to propound questions to the applicant for a search warrant. And then this question and answer exchange was reduced or taken by stenographic notes. The reason why the judge did that was he was then in a trial, and therefore he did not want to disrupt the proceedings. So after the trial, he went to his chamber and asked the stenographer to read what she had recorded, after which he issued the search warrant. The Supreme Court said, that's wrong. It is a personal duty and undertaking of the judge. He cannot delegate it to anybody else, not even his clerk of court. In regard to the determination of probable cause by the judge for the purpose of issuing a warrant, as we said earlier, it may happen that the accused would ask the judge that he make a determination of probable cause, meaning that the mere filing of the information or the mere presence of the records before him should not be enough. So he may need additional evidence or witnesses. In the case of AAA versus Carbonell, so AAA here is not a battery size. The complainant filed a complaint for rape against her employer. A preliminary investigation was conducted by the public prosecutor, after which he found probable cause and therefore filed the appropriate information in the court of Judge Carbonell. The accused asked for determination of probable cause, and the judge required AAA and her witnesses to show up. They did not. So what the judge did was not only not issue the warrant of arrest, but proceeded to dismiss the case altogether. The case was elevated to the Supreme Court, and the Supreme Court said there was grave abuse of discretion on the part of Judge Carbonell. Why? The judge is supposed to primarily determine the existence of a probable cause based on the information and the records before him, such that if the records are good enough, then there is no reason to still require the complainant or her witnesses to show up. And the court, looking at the records themselves, found that the records were sufficient to indicate to the judge that there was probable cause. So to still require the presence of the complainant and to eventually dismiss the case for their failure to appear, that constituted grave abuse of discretion. As we also discussed earlier, the person appearing before the judge should have personal knowledge. In the case of People versus T, the Supreme Court said that if the policemen are asking for a search warrant, for instance, it did not necessarily be the case that the policemen themselves have personal knowledge. Which in the nature of things, they may not have personal knowledge in regard to a crime for which they are now seeking a search warrant. Because if they have personal knowledge, they might as well have immediately made the arrest or the search, you know, if they witnessed the commission of a crime. So it generally happens that they may rely on others to supply the personal information. So it would be the witness or witnesses that they produce before the court. In this case, the witness that the policeman used to supply the personal information was the taxi driver that helped T in the transportation of marijuana to his residence. In the case of United Laboratories versus ESIC, the Supreme Court had occasion to talk about the nature of search warrant proceedings, particularly in regard to who may have personality to participate. The Supreme Court said that the complainant or the one seeking the search warrant may have personality to participate. Like in this case, it is United Laboratories. So it's a private corporation. It claims that somebody was selling fake products, which would thereby injure its reputation. Subsequently, the person whose premises had been searched and from which certain items were taken, filed a motion to quash the search as well as for the return of the items seized. So in that instance, United Laboratories would have personality to participate, to oppose the motion to quash. And if it is granted, to further go up and defend the validity of the search warrant and the resulting search. So in this case, you can see the title is United Laboratories versus ESIC. United Laboratories was able to prosecute this case, or at least in regard to the search warrant aspect, all the way to the Supreme Court. With respect to, again, the requirement for particularity of description, you have to remember that this is relative. So, what may be particular in one instance would be considered as general in another instance. Good examples for this would be the cases of Central Bank versus Morphe and Stonehill versus Jokno. In the case of Central Bank versus Morphe, the search warrant made reference to books of accounts, ledgers, and similar descriptions to signify or to identify the records that were supposed to be seized. In Stonehill, the same wording was also utilized. But in the case of Stonehill, the Supreme Court said that's too general. You should have specified what particular records or transactions. But in the case of Morphe, it was okay. So what's the difference? In the case of Stonehill, Stonehill was doing a legitimate business. So if ever there might have been crimes committed by him, they would be in regard to some specific transactions. But the way the search was worded, it would mean that each and every book or ledger that Stonehill might have would be subject to seizure, even if they have nothing to do at all with the crime for which the search is being made. In the case of Morphe, the corporation that was searched was engaged in illegal banking. So every transaction that it did would be in regard to that activity. Accordingly, the books, the statement of accounts, and so on would all be part of that general criminal undertaking. Again, going back to the case of the Supreme Court said that a description of marijuana in these terms, undetermined amount of marijuana, is good enough. But it did not specify the weight. It did not specify the dimension. The Supreme Court said, under the circumstances, that would be the best way to describe that particular contraband. You don't know the weight. You don't know the dimensions. But you know that there is marijuana in that particular place to be searched. So, saying that it is undetermined amount of marijuana would be good enough. Going back to Stonehill, that case also decreed that a single warrant should refer only to a single crime. So you cannot lump together in one warrant several crimes, because that would make it practically impossible for the judge to determine the existence of a probable cause. How would you expect the judge, for instance, to know the probable cause for violations of the revised penal code, tariff and customs code, as well as the internal revenue code? Accordingly, the Supreme Court said, one crime, one warrant. However, in Dichoso, the Supreme Court said that the crimes found in the Dangerous Drugs Act may be lumped together in only one warrant because they are interrelated. As a matter of fact, the code itself is a special law that precisely codified the laws on drugs. So since they are interrelated, then one warrant may be issued, for instance, for illegal possession of shabu, illegal possession of marijuana, illegal possession of drug paraphernalia. Can you ask for a search warrant to search a place and seize contraband to be delivered yet in the future? Today is Tuesday. Let's assume that the police have been tipped off that tomorrow a shipment of shabu would be delivered at a particular house in Dapitan. So this early, they already went to a judge asking for a search warrant to search that particular house after the shipment of shabu would have been delivered tomorrow. So there is yet no shabu in the place. But tomorrow, reliable information says it would be delivered. Can they now ask for a search warrant so that they'll be ready to search that house the moment they see the shipment? In the case of United States versus Grabs, the Supreme Court said that in a sense, all warrants are anticipatory. Anticipatory because at the time when they are asked for, it is anticipated that when the warrant would be served, that which is supposed to be seized would still be there. So that ordinarily would be the case. But in this particular case, the item is yet to be delivered. And the court said it's okay. Because what's important is that the place be particularly described, and there is more or less the certainty that the contraband to be confiscated would be delivered, that the triggering mechanism would occur, which is the delivery of the contraband. But it would be a different story if the policeman would simply ask now for a warrant that they can use whenever a crime might be committed. Because the commission of a crime, a particular crime for instance, is not certain. That would not then constitute again some sort of a fishing expedition. So if they are certain that the triggering mechanism, such as the delivery of the contraband, is certain, then they may ask for that kind of a warrant, anticipatory warrant. For some, perhaps, you're also preparing for your anticipatory blowout, isn't it? Like, you now have to start growing the pigs, the cattle, and the goats that you would need come April next year. Anticipatory blowout. In regard to the service of warrants, you can again appreciate the idea of reasonableness. What is it now again? Is it a woman's world or a man's world? Woman's world. So when a girlfriend, for instance, would go to the house of her boyfriend, does she just barge in? What's the normal way by which she can be admitted into the house? It's knock and announce, right? You knock at the door, or at least the equivalent of knocking at the door, so that you would be let in. Unless, of course, you're trying to catch your boyfriend in the act. In the same way, in the service of warrants, there is this so-called knock and announce rule in the US and in the Philippines, referred to as knock and announce procedure. That's found in Rule 126, Section 7. And it was made reference to by the court in that case of People versus Go. In that case, the policemen were armed with a search warrant. When they went to the place to be searched, they did not follow the knock and announce procedure. Instead, what they did was to bump a vehicle parked in front of the house. What for? Their explanation, in order to induce the occupants of the house to come out. The Supreme Court said, but why did you do that? you're not even certain that they would not come out if you followed the knock and announce procedure. It was improper. You should have simply followed the normal way. And in regard, again, to service of warrants, timing also goes to the idea of reasonableness. Normally, warrants are served at daytime. In exceptional circumstances, it may be served at night time. In the case of People versus Court of Appeals, we have a situation where a warrant was served at 7:30 in Parañaque. Supreme Court said 7:30 in the evening in Parañaque would still be reasonable time to serve the warrant. Because at this time, people would still be up and about in their normal activities. But it may be a little different if you were to serve the warrant in some other places, like in the provinces or rural areas where there is no electricity. At 7:30 in the evening, people might already be trying to generate their own electricity. So it would really be very unreasonable to interrupt them in that energy-producing activity, isn't it? So, again, idea of reasonableness is present. When you watch at times these newscasts, did you ever see an incident where the media men are closely trailing policemen in entering residences, raiding or serving warrants? In the United States, this is referred to as media ride-along. In the case of Wilson versus Lane, the policemen entered the house of the Wilsons. They were armed with a warrant of arrest for the son of the Wilsons. Unknown to them, that son was no longer staying with the parents. When they entered the house surreptitiously, they allowed or they invited members of the media to go along with them. At the time when they entered, the Wilson spouses were still in bed. They heard noise downstairs, so the husband, still in his underpants, went down. And he was surprised to find that in the living room area were already policemen and members of the media. And what made it worse was the fact that he was mistaken by the police as the person to be arrested. So they wrestled him to the floor. Pictures were taken, but since they realized that he was not the one, then these pictures were never published. Just the same, the Wilsons sued the police for violation of their right to privacy. It is not because the police went in, but it is because they invited the media to go with them. So there is a conflict here between right to privacy and freedom of the press, which should prevail. The Supreme Court said that both rights are highly cherished in a free society. We need a free press to report on what is happening so that the people will be better informed. But we also have the right to privacy, where people can expect that they would not just be intruded into or disturbed in their houses. So how do you now weigh these considerations? The court concluded that a warrant in the hands of the police would justify them to enter residences, because that is authority for them to effect what is in the warrant. So there would be no violation of the right to privacy in that way. However, the Supreme Court also explained, the warrant is only authority for the police. It does not similarly command anybody else, including the media, to do anything under that writ. Therefore, while the warrant may justify the entry of the policeman, it did not similarly authorize or justify the entry of members of the media. Accordingly, if the media had been invited inside the house by the members of the police force, then the police can be liable for violation of the occupant's right to privacy. In this particular case, however, the Supreme Court said that the policeman could not be held liable because at the time when this occurred, there was yet no definitive ruling as to whether there would really be a cause of action against the policeman. The different courts in the U.S. were not unanimous. So with this decision by the Supreme Court, there is now a definitive ruling saying that the policemen cannot invite members of the media inside private residences when they're serving warrants. An interesting case also is that case of Los Angeles County versus Repellents. The policemen here again were armed with the warrant. Warrant for the arrest of certain African Americans, blacks. Unknown to them, these suspects already left the place months earlier. And the house is now occupied by retail, Caucasian, or white. So they went in and they surprised Retail and his girlfriend in bed, naked. So what did they do? They watched? No. They asked them to stand up. And they did not allow them to cover themselves up or put on something for about 2 minutes. So can you now imagine yourself in that situation? A chance for you to be appreciated perhaps for whatever physical assets you might have, if ever there is any. So is that unreasonable or not? The lower courts said it is unreasonable. They were looking for African Americans. They instead saw a pair of Caucasians. So obviously, they are worlds apart. That should have already stopped them from conducting further searches. And they did not allow these persons to immediately cover themselves up. When the case reached the Supreme Court saw otherwise. The Supreme Court said, yes, they might have been looking for African Americans, but nowadays in the U.S., it's not far-fetched for people of different races to stay together. So it is possible that in the room where they found Repel and his girlfriend, they saw Caucasians. But that did not preclude the possibility that the suspects may be hiding in some other rooms of the house. So there was a justification for them to conduct further search. What about their act of not allowing Repel and his girlfriend to cover themselves up? That's also justified according to the Supreme Court. Why? Because if these two persons were part of a criminal conspiracy, there is a great danger that they would also be armed. Therefore, there was a need for the police officers to ensure that their safety would not be compromised before they allowed the two to take some other or to do something else. If they immediately allowed them to cover themselves up, there's a possibility that they might have actually been sleeping with weapons. So if on the pretext of grabbing a blanket, for instance, they instead grabbed a gun, and they could have immediately used the gun against the police officers. Accordingly, there was a need first for the policemen to be sure that there would be no danger to them before they allowed the two to do something about their state of nakedness. So the next time you sleep, you know better than to go natural, right? In relation to addresses, we have another case titled People versus Court of Appeals. The search warrant was addressed to Abigail Variety Store. When the searching team went to that place, they did not go to Abigail Variety Store. Instead, they went to apartment number 1, which is next door. In that apartment, they found what they were looking for, and therefore, the occupants were charged. The Supreme Court acquitted them. Why? The Supreme Court said a search warrant cannot be utilized to search a place other than what is specified in the warrant. Since what was in the warrant is Abigail Variety Store, then it could not have justified the policeman in entering apartment number 1, even if apartment number 1 yielded the evidence that they might have been looking for. So how did they happen to commit that mistake? The policeman explained that they had in mind all along apartment number 1, but through some oversight, what was indicated was Abigail Variety Store. The Supreme Court said even if that was how it was, still cannot justify what you did. You have to remember that when the judge authorized you to search a particular place, that would be the extent of your authority. So when the judge issued the warrant with the address Abigail Variety Store, it meant that the judge found probable cause for you to enter and search Abigail Variety Store. You could not have any other authority for other places. It was only for Abigail Variety Store. How about if there's a discrepancy in the address appearing in the caption as against the body of the warrant? It's the same street name, but different city. So we have the case of Oy versus Bureau of Internal Revenue. The warrant specified a street name supposedly found in Cebu. That's in the caption. In the body of the warrant, the same street name was indicated to be in Mandaue City. When the warrant was served, it was served at that street name in Mandaue City. Is the warrant valid or not? The Supreme Court said, yes, it is valid, no problem. But there was a discrepancy. Even then, the Supreme Court explained, because you have to remember that the warrant is supposed to indicate to the officers where they are to go. So if they were not misled by that warrant, then there's no problem. How could they not have been misled if there are two different places specified in the warrant? The Supreme Court answered, it's simple. That street name indicated in the warrant existed only in Mandaue City. There's no such street name in Cebu. Therefore, the policeman could not have been misled into any other place than that street in Mandaue City. In the case of Peacock versus Asuncion, the warrant was for the search of the aforementioned premises. Anything wrong with that? The Supreme Court said yes. Why? Because the so-called aforementioned premises consisted of about 150 hectares. So you can just imagine how vast that area is. And that area had several buildings, bank houses, offices, cottages, and so on. So, if you gave that kind of authority to the policemen, then they would now have a roving commission to turn upside down everything in search of whatever they might be looking for. Like that small town, for instance, or even perhaps bigger than a town, they could now have a free rein searching everywhere. They could now enter any cottage, any apartment, any warehouse. And you can imagine how unreasonable it would be. In regard to search witnesses, take note that there is such a thing as hierarchy of search witnesses. And that was referred to in the case of People versus Go. So the enumeration found in Rule 126, Rule Section 8 should be followed. The occupant or the relatives, and then outsiders. You cannot immediately bring in outsiders if the occupant is present or the relatives are present who could witness the search. And in the case of Sony Computer Entertainment versus Bright Future Technologies, the Supreme Court also said that if ever you are to make use of outside witnesses, then they must be present from the very start of the search and not midway. Of course, the reason is obvious. If you simply bring in these witnesses midway through the search, then it would defeat the purpose. Because what if before these witnesses showed up, the policemen were already able to plant evidence, such that when these witnesses would finally be at the scene, that's the time that they would claim they have discovered this contraband. So how could these witnesses now attest to the regularity of the search when they were not present from the start? So they must be there from the start and not midway. In regard to the lifetime or validity of a search warrant, you have the case of Mustang Lumber. A warrant has a lifetime of 10 days. So if the search was to begin, let's say today, and today is just the 4th day of the warrant, and the search is not concluded today, and there's still some things to be done tomorrow, then the search can continue tomorrow, making use of the same warrant. However, if this is already the 10th day, and the search and seizure has not been concluded today, it cannot be continued tomorrow under the same search warrant. So you would have to secure another warrant. Now let's proceed to the warrantless searches. So again, the general rule: for a search to be valid, there must be a warrant. Now, the exceptions. One exception would be search incident to lawful arrest. This means that there must be a lawful arrest that precedes the search, because it is the presence of the lawful arrest that justifies the resulting search. What is the justification to this? You only have, again, to visualize what happens. When the policemen make an arrest, it's not as simple as that. They also have to ensure that their own safety would not be placed in danger. Because if they just make an arrest and thereafter turn their back, and it's very possible that the moment they have turned their back, the person that they arrested might be able to grab a weapon that he might just have placed nearby and use this against the arresting policeman. So there is a need for the policemen to protect themselves. Also, when the policemen make an arrest, there may be need for them to secure the evidence. So they would be justified in conducting a search within the immediate control of the person arrested. Because if they simply made an arrest and did not try to locate the evidence that they may use against him, they may have a person arrested, but no evidence against them. So how would they proceed to prosecute him? If they simply make the arrest and leave at once, then somebody may go there and thereafter destroy or run away with the evidence. So once more, there must be a lawful arrest to precede that incidental warrantless search. And that also means that the area that is subject to allowable search is limited, not very extensive. The reason for justifying it would also provide the basis for delimiting the area. So if it's already far removed from where the person was arrested, it could not justify an incidental search in some other places. Like the case of Yang Siri. He was arrested in one room of a hotel, and a subsequent search was made in another room of the same hotel, but found in a different floor. So the court said that's already far removed from the scene of arrest. It cannot anymore be considered as a search incident to lawful arrest. In the recent case of Valeroso, Valeroso was arrested in his room. He was brought out and placed in handcuffs. Thereafter, the policeman went back to his room and allegedly found a gun in a locked drawer inside the room. Would that fall under search incident to lawful arrest? The Supreme Court said no, because it would no longer fall within that particular exception. You have to remember that Valeroso had already been removed from his room. He had already been placed in handcuffs. So he could not possibly have gone back to his room and get the gun to possibly assault the arresting officers. And moreover, the gun was in a locked drawer. So it would not have been that easy for him to immediately unlock the drawer. So even if there was an unlicensed gun recovered in that room, in that drawer, it would not be justified under this search incident to lawful arrest. In the case of People versus Lagio, the policeman got a tip about a person who allegedly supplied drugs. They were directed to where he might be, so they went there. Then they saw him walking from his house to his car. And while walking, they arrested him and thereafter searched his car. They found drugs. Would that fall under this exception? The Supreme Court said no. Why? In the first place, the arrest was not lawful. There was no basis to make a warrantless arrest. The simple act of walking from one's house to the car could never be characterized as committing a crime. There's nothing to indicate that he was committing a crime. So if ever he might be committing a crime, that would only be discovered after you have already conducted an unlawful arrest. So the warrantless search of the car was not justified. Another exception would be the so-called plain view doctrine. If you see someone really ugly, then no matter what, he's ugly, right? It's plain. So the same way when it comes to contraband, more or less policemen know what a contraband is from legitimate things. If it is marijuana, then they should know it is marijuana or shabu. So under the plain view doctrine, the item or the article can be seized without a warrant. But this also has its requirements. One would be the presence of a prior justification to be in the place where the officers were. Then the discovery must be inadvertent, accidental. The policemen were not really looking for it, they just chanced upon it. Then it must also be shown that there is an immediate apparent illegality. Just by looking at it, you already know it is contraband. It is shabu, it is marijuana, it's a drug paraphernalia, or such other things. And plain view, without further search, would justify its immediate seizure. In the case of Salangit, the policemen were armed with a search warrant. It was for the search and seizure of shabu. So they went to the place, and when they came out, they had the shabu plus marijuana wrapped in newsprint. The search warrant referred only to shabu. So what is now the justification for the seizure also of marijuana? The policeman said, plain view. The Supreme Court said it could not be under plain view. Why? The search warrant gave them authority to search the place in order that they may seize shabu. So it is reasonable to assume, the Supreme Court explained, that when they went to the place indicated in the warrant, they already knew where the shabu was. And they must have immediately gone to that particular room where the shabu was placed. After they saw and got the shabu, their reason to be in that house already came to an end. Their authority became pompous official. So the only thing that they could have done after that was to get out of the house. In this case, it appears that the marijuana was found in some other parts of the house, meaning they still went around the house instead of exiting the house. So if they found the marijuana in some other parts of the house, and which was the result of their going around, then that would not be in plain view, because they did not have anymore a prior justification to be in any other part of the house after they have accomplished their mission. So it would have been different if on their way out they chanced upon the marijuana. But in this case, they saw it in some other part of the house as a result of their active going around. And moreover, the Supreme Court said the marijuana was wrapped in newsprint. So that does not fall under the plain view doctrine. Because under the plain view doctrine, if the contraband is in a container, then it could not be considered as in plain view. What is in plain view is the container, not the contents. The exception to that would be if the container would proclaim or broadcast the nature of its contents. And to the Supreme Court, a marijuana wrapped in newsprint is not marijuana in plain view. Because what would be seen would be the newsprint, not the marijuana. In this case of Salangit, the Supreme Court also spoke about partially void warrant. The warrant issued here was for the search and seizure of shabu and drug paraphernalia. The court said the reference to drug paraphernalia is void. So in that regard, the warrant is partially void. Why? The Supreme Court said that when there was an application for a search warrant, it was for the search and seizure of shabu only. So what was testified to was about the presence of shabu. There was nothing said about drug paraphernalia. Accordingly, there could have been no probable cause to issue a warrant for drug paraphernalia. So, to the extent that the search warrant made reference to a drug paraphernalia, that was void. With respect to moving vehicles, the justification for warrantless searches is the nature of the vehicle itself. It is subject to immediate or easy transfer. Accordingly, if you still have to wait for a warrant before you can search a vehicle, it may happen that by the time you have that warrant, you would no longer have a vehicle to search. Nevertheless, take note of what the Supreme Court said in the case of Caballes. In this case, the Supreme Court said the mere fact that what is involved is a moving vehicle does not give the police authorities unbridled discretion to stop and search each and every vehicle that might strike their fancy. There must still be a probable cause to stop a vehicle and thereafter conduct an extensive search. So it's not because the vehicle might be of an unusual color that would then make the policemen want to stop it and then search it. So if in the process they found contraband, that would be inadmissible. In the case of Caballes, anybody here from Pagsanhan? Policemen chance upon a jeep at around 9 o'clock in Pagsanhan. Its back was covered with leaves. And to the policemen, this was quite unusual. So they stopped the jeep and thereafter looked under the leaves at the back. And they found sacks. Inside the sacks were copper wires, obviously stolen national power transmission lines. So the occupants of the jeep were prosecuted, they were convicted, but when the case reached the Supreme Court acquitted. And the reason given was that the search in the first place was unlawful. Why is that? The Supreme Court explained that the policemen here did not really have a probable cause to stop the jeep. The mere fact that its back was covered with leaves is nothing unusual, especially in the provinces. So that cannot possibly give rise to a probable cause of suspecting that it might be involved in a criminal undertaking. Therefore, if there was no valid basis to stop the jeep, then the resulting search would be useless. Related to moving vehicles would be checkpoints. The general rule when it comes to checkpoints is visual search or inspection. And that means that those manning the checkpoints should only be looking inside from the outside. They would not ask the occupants of the vehicle to step out or even to open the glove compartment or the trunk of the car or the vehicle. It would only be if there is some indication of sufficient basis to arouse suspicion that those manning the checkpoints may conduct a more extensive search. Example would be the case of Binacario. So 3 men were riding a motorcycle. They passed by a checkpoint. They did not stop. They simply slowed down. The men manning the checkpoint asked them to return. So they returned. And then the policemen noticed that these men riding the motorcycle were nervously passing among themselves a knapsack. So when they were ready before the policemen decided to open the knapsack and they found drugs. The court said this is a valid search because the actuations of the men in the motorcycle gave justification on the part of the policemen to conduct a more extensive search. In regard to checkpoints 2, you have to remember once more that what is prohibited is unreasonable search. So, if the criminal elements have now adopted, for instance, the style of the insurgents in Iraq or Afghanistan, where they practically convert vehicles into bombs, would it still be reasonable to simply follow this visual search or inspection routine? It would not be reasonable enough already, and it would even be unreasonable perhaps if they simply followed that kind of checking, is it not? For instance, it is now widely reported that several criminal elements plan to bomb important buildings in Metro Manila using car bombs. So checkpoints are now set up all over. At Welcome Rotonda, for instance, at Nagtahan, at Quiapo, and so on. would it be reasonable to simply look at the passengers, and if you find nothing suspicious, then you just let go without conducting a more extensive search? So let's say some persons riding a car came from Quezon City. They passed by a checkpoint at Welcome, and they looked innocent enough, like bar reviewists. So the policemen manning the checkpoint simply let them go, and they're now allowed to come here. They park the car at the car park, and after a few minutes, a huge explosion would now render the hospital insufficient to attend to the needs of those from the car park. So, if the use of vehicles would be in that regard, it would be unreasonable to simply follow the usual rules. So, you have to determine what is reasonable under the changing circumstances. Law measures would also have to adjust to the changing times or circumstances. In customs searches, this is somehow related also to moving vehicles. For one, articles imported from abroad have to pay duties in order that their entry may be legitimate. For another, you also have to remember that generally imported goods are transported through vehicles. So you give these two factors together and you would have a better understanding of this exception regarding customs searches. Terry stop and frisk, or the Terry pat down. This is also a recognized exception. This originated from the case of Terry versus Ohio. In this case, a policeman noticed that two men alternately passed back and forth for several times in front of a store. Every time they passed by the front of the store, they would stop for a while and look inside. So this went on for some time. The policeman also noticed that after they would have this, or they would have done this round, they would confer with the third man in some other corner. So after a while, the policeman already decided to act. He approached them and immediately patted them down. He found in the person of Terry a gun tucked in his waist. Terry was prosecuted together with his companions, and there was a claim that this would be a violation of the guarantee against unreasonable searches and seizures. The Supreme Court of the U.S. said this is consistent with the guarantee against unreasonable searches and seizures. This is reasonable. The Supreme Court explained that while policemen may generally be there for the purpose of solving crimes, it would be better if they can help prevent the occurrence of crimes. So they don't have to wait for a crime to be committed before they could act. In that particular case, the policeman observed something, which his experience, his training, and some other parts of his character may have indicated to him that there was a crime about to be committed. The behavior of the men were consistent with the possibility that they were casing the store preparatory to robbing it. So the policeman could have waited for the robbery to actually take place before doing anything. Or he could have done something before a crime could actually occur. Which would you prefer? If the policeman waited for a crime to be committed, and it was committed, what if in the process of robbing the store, somebody was killed? Would you prefer that? At least you are now certain that there was a crime committed. Or it would be better that the policeman would now undertake preemptive measures, such as immediately frisking them and doing some other things to ensure that if ever they were going to commit a crime, they would not be able to consummate it. So if the policeman really had a good idea of what they might be planning to do, then he was justified in taking action. Further, if consistent with his idea that they were about to commit a crime, he would also be justified in frisking them because they are likely to be armed. If they were to commit a crime, of course, they would be armed for that purpose. Therefore, there was also a need on the part of the policeman to protect himself by immediately frisking them in order to ensure that if ever they had a gun, which they might have originally intended for the crime, they would not use it on him instead. And in this particular case, the suspicion of the policeman was justified. There was a gun in their possession. So this did not constitute an unreasonable search. Under the circumstances, this is something that a policeman could very well do. In the Philippines, however, take note of the case of Malacat. In this case, somebody was observed in one side of Kiap with fast-moving eyes, moving from left to right and right to left and so on. And the policeman did something rather suspicious. So they started to approach him, and he started to move away. When the policeman got closer, he started to run. So they gave chase, and they eventually caught up with him. They then found grenade in his person. So he was prosecuted for that, but the Supreme Court said the mere fact that he might have been standing in one side of Quiapo with fast-moving eyes was not good enough reason to suspect that he might be about to commit a crime. A mere hunch is not enough. Therefore, if they tried to go near him and he ran away and they gave chase, since there was no justification for going near him in the first place, the resulting arrest and confiscation of the grenade would not help the police. The case cannot prosper. Okay. In regard to consent, make sure that mere silence on the part of the person searched would not be equated with consent. So consent must be more than passive silence. It should indicate that the person searched knew that he had the right not to be subjected to search and still consented to the same. So mere silence does not translate to consent. And that's realistic too, isn't it? If a person, for instance, is now confronted by several heavily armed policemen, would it be better for him to protest or simply keep quiet? he makes noise, and that might be the last time you'll ever hear from him, right? Because he would then be eternally silenced. Until what age are, again, women productive?
13.
Has it already been altered by modern science or what? Or, I think a safe bet is that shortly after passing the bar, right? Okay, let's just say it's around 45. And this brings us to the case of Lila Johnson. Lila Johnson is around 58 years old. A widow. She was a former Filipino, but she had already been naturalized as an American. So just like many former Filipinos, she also came to visit the Philippines. Then after a few days stay, she prepared to go back to the U.S. You very well know that if you want to go to the U.S., you're subjected to greater security precautions compared to going to some other places. So there would be several strata of security checks. The last one would be just before the boarding area. And she was subjected to a body frisking by a lady frisker. The lady frisker noticed that there was something hard near the abdominal part of Lila Johnson, which is quite unusual. Because if it's a guy, then perhaps you can excuse it, right? But it's a woman. So the lady frisker asked, "What's that hard thing?" And Lila Johnson said, "Oh, that's nothing. It's just that I have to make use of 2 panty girdles because I just had an ectopic pregnancy operation." And as you very well know, ectopic pregnancy is that kind of pregnancy that occurs outside of marriage. The lady frisker, being a woman herself, must have known better. So she said, "Can we go to the ladies' room and for you to take out that hard thing?" So they went to the ladies' room, and when Lila Johnson took out her girdles, it turned out that that hard thing was a sachet of shabu. So she was prosecuted, and she claimed that there was a violation of her right against unreasonable searches and seizures. The Supreme Court said the greatest amount of privacy expectations that you can have would be in your house. The moment you step out of your house, to that extent would your privacy expectations also diminish. When you decide to ride a plane, you must also be ready to surrender some of your privacy expectations because of modern developments like hijacking and the like. There's a need to undertake all of these security precautions. These are reasonable searches. So, your person, your luggage may be subjected to X-ray, body frisking, and the like. And if in the process, contraband might have been discovered, then you can be prosecuted for whatever crime you might have committed. So, when you were subjected to body frisking, as a consequence of your desire to board the plane, and the shabu was found in your body, then that can be used as evidence against you. Then towards the end of the case, the Supreme Court also added some element of humor. The court said, return her passport, her plane ticket, and her panty girdles because they're not to be used as evidence against her. What you only need would be the sachet of shabu. Another case involving a woman passenger who also tried to beat the system is Canton. Susan Canton. He was bound for Saigon, and she was also subjected to frisking, and she tried to conceal the sachets by placing them near her private parts, but still she was discovered. And in that case of Susan Canton, the Supreme Court said that now one of the recognized exceptions to the search warrant requirement would be airport searches. So they have now added airport searches as one of the allowable warrantless searches. Now let's talk about drug testing, courtesy of that old man. Social Justice Society versus Dangerous Drugs Board is celebrating 75th year. Is it not? And it doesn't look like he's 75. More like 95. Are you done with it? One more year? There's so many ideas. Take a look at this avocado. Also, avocado versus Purissima. Have you read that?
Yes.
So in the case of Social Justice Society versus Dangerous Drugs Board, Attorney Alcantara questioned the constitutionality of those provisions of the Comprehensive Dangerous Drugs Act, which required drug testing for almost everyone: students, employees, those running for public office, and those charged with crimes punishable by more than 6 years imprisonment. Senator Pimentel also filed subsequently a petition questioning the constitutionality of the same law insofar as it demands drug testing for those running for the position of senator. In regard to the petition of Senator Pimentel, the Supreme Court agreed with them, because Senator Pimentel claimed that requiring drug testing for those running for the position of senator would be adding to the qualifications of senators. But according to the Constitution, since it enumerates the qualifications, then Congress cannot add to the same. So it should be limited to citizenship, age, residency, being qualified or being a registered voter, and being able to read and write. There's nothing about being free from drugs. But what is somehow puzzling is why the Supreme Court had to invalidate the entire subsection for drug testing for candidates. Because the reasoning was only insofar as those running for public office or public national offices are concerned. Because these are the positions in which the qualifications are set out in the Constitution. When it comes to local elective positions, it's well within the power of Congress to provide qualifications. They are provided, or they are set out, for instance, in the local government code. So if Congress can provide the qualifications for those running for local elective positions, then it can come up with an additional requirement that they should be drugs-free. But apparently, the Supreme Court did not consider this anymore. I know that there was a motion for reconsideration that was filed, but I'm not aware if it has already been resolved. Because the court could have made use of this opportunity to perhaps clarify that it should only apply to local elective positions but not for national elective positions. Anyway, with regard to drug testing for students and employees, the Supreme Court upheld these requirements. For students, since they're under the care of the schools as substitute parents, then it is well within the authority of the school to ensure that the students would be safeguarded. The drug menace is real. Therefore, there is a need to undertake measures like this for the protection, especially of the children. For employees, the employer would also have a need for the kind of workplace that would be conducive to what it is supposed to be doing. And of course, drugs in the workplace would also affect the order in that place. As for those who are charged with crimes punishable by more than 6 years imprisonment, the Supreme Court said it is already a different story because it lacks the element found in drug testing for students and employees. What elements? Randomness and suspicionless drug testing. So for students and employees, you don't specify, you don't choose. It is random. So there is no suspicion. In the case of someone who is charged with a crime punishable by more than 6 years imprisonment, it's no longer random. It's no longer suspicionless. They're precisely made to undergo drug testing because they've been charged with particular crimes. So that law can no longer withstand constitutional scrutiny when it comes to those charged with crimes. So that's the case of Social Justice Society versus Dangerous Drugs Board. Now let's talk about modern technology. You have to remember that the counterpart of our Section 2 on searches and seizures had been part of the U.S. Bill of Rights since 1791. So you can imagine what kind of world there was in that year, 1791. No electricity, therefore no brownouts. No gadgets as we know them now. Accordingly, the Fourth Amendment, which is the counterpart of our Section 2, was initially understood as referring to physical intrusion only. Like if the government were to physically enter your house. But nowadays, with modern gadgets, the government can have the equivalent of entering your house without actually physically going in. So the problem would be, would the Fourth Amendment apply to those kinds of situations? For that, we have the case of Kylo versus United States. To better appreciate this case, try to think and ask yourself, would the heat that your body emits be the same when you are lying all by yourself as when you are lying with someone else? Would the amount of heat be the same? Obviously, no. So we have this case of Kylo. You may give it the subtitle of body heat. Generally, growing of marijuana is prohibited in the U.S. Therefore, if you grow it outside your house, then it may be found out. So what others did, just like Kylo, is to try to grow it inside the house. But it turns out that if you were to successfully grow marijuana inside your house, you have to approximate the light and heat coming from the sun. Therefore, you need spatial lighting. In this case, the policemen suspected that Kylo was growing marijuana inside his house. But they had no sufficient proof, aside from the unusually high electrical consumption. So what they did was to make use of a thermal imaging device. And you can more easily understand that simply because of the swine flu epidemic last year. They were making use of thermal imaging device to find out how hot you are. What the policeman did then was to direct the thermal imaging device at the house of Kylo. The policemen were simply seated in their police car across the street. So they directed the thermal imaging device. And when the results came out, their suspicions were somehow confirmed that the spot where they thought he was growing marijuana emitted the greatest amount of heat. Armed with this result, they now went to a judge to get a search warrant. The search warrant was issued, it was served, and they indeed found the marijuana in the spot where there was the greatest amount of heat. Kylo objected to the use of the thermal imaging device for the purpose of establishing probable cause against him. And the U.S. Supreme Court sustained him. At this time, the use of thermal imaging device is not yet that pervasive. It would be unreasonable because perhaps the citizens would then be exposed to the kind of governmental intrusion, a virtual intrusion, which would be equivalent to a physical intrusion under the Fourth Amendment. Therefore, when the use of such machines is not yet that prevalent, it is unreasonable to rely on it now for the purpose of determining the existence of a probable cause against Kylo. So there seems to be a suggestion in that decision that if in the future it would become more pervasive, then it would already be reasonable to admit the results of these thermal imaging devices. Let's take a break.
Katapos na si Patrick. Pinatapos ka na yan.